At this time, I'd like to introduce our presenters. I'd also like to thank each of them for the time and effort spent in preparing for this webinar, as well as for sharing their expertise on this important and very timely topic. Our very own association president, Michael McGuffin, will look at how FDA did and did not address key concerns raised by AHPA about the 2011 draft. Tony Young, partner at Kleinfeld, Kaplan & Becker, LLP, and AHPA's general counsel, will discuss key takeaways from the latest revision of the NDI draft guidance and NDI-related legal realities of the Federal Food, Drug, and Cosmetics Act. And finally, Wes Signer, director at Hyman, Phelps & McNamara, PC, will explore next steps for the industry with respect to the revised draft NDI guidance. Full speaker bios with contact information will be included with the materials you'll receive post-event. As a reminder before we begin, the American Herbal Products Association is pleased to provide the information presented in today's webinar. The presenters are deemed experts in their respective areas in which they are presenting, but their comments may not necessarily reflect the opinions and positions of AHPA. All materials are copyrighted and are the property of AHPA and may not be reproduced without the express consent and permission of the association. With that said, I'm going to turn the floor over to our presenters. Michael?
Thank you very much, Natasha and Haley, for getting us started, and welcome everyone. We all appreciate your time and attention here today, so we will try to provide valuable information to all of you. Next slide, please. As Natasha mentioned, my focus is going to be, no, one more up, next slide. My focus is going to be on what did FDA do with regard to AHPA's comments. So FDA issued the draft guidance in 2011. AHPA and others filed comments. We were very critical in our evaluation of the 2011 draft, and these issues pointed out on this slide were some of our key issues, the places that were of most importance to our members. And so most of my presentation is going to focus on these key issues. There are a lot of other details. I think Wes and Tony might get to some of those, and you've certainly seen mention of other details in the trade press. And I will say right at the outset, I am guardedly optimistic. I think we did make some progress between 2011 and now. At the same time, there's a lot of work that still needs to be done to pull this guidance back into a more strict compliance with the statutory framework and with our actual obligations under the law. So again, each of us will touch on this. Next slide, please. I'm going to start with this issue of, actually I want to start with the purpose of the guidance. I think this is really important that it makes us understand what FDA was trying to do. And in 2011, you can see that FDA stated that the guidance was focused on helping provide information for notifications for dietary supplements, dietary ingredient, and that the agency also identified an interest in improving both the quality and the quantity of notifications. One of AHPA's comments is quantity doesn't matter. What we actually want is that the required notification should be submitted. More isn't better. The right number is what's best. So if we move on to the next slide, we can see that FDA both extended so that they now say the guidance is intended to help manufacturers and distributors of both the ingredients and the supplements in submitting their notifications. And then these last 2 points, one key goal is to improve the rate of compliance. That's so much better language than the number. And the second goal is to improve the quality. I think those last 2 points are really important, and if that's what FDA really wants to accomplish, to improve the rate of compliance, that's what we want, and to improve the quality of notifications, that's what we want. Again, we'll point out that there has been some progress toward those goals, and I think still more work to be done if we're really going to achieve those goals. Next slide, please. So one of really the biggest issues is the draft guidance, the 2011 draft guidance really implied a lot of duplicative notifications, and I'm stopping here to just go back to what the statute says. So the Food, Drug, and Cosmetic Act is Section 413A, establishes that a dietary supplement that contains a new dietary ingredient is adulterated unless it meets one of these two requirements. Either it contains only ingredients that have been in the food supply, or there's a history of use and other evidence establishing the safety, and the manufacturer or marketer 75 days prior to introduction and delivery into commerce, the manufacturer or distributor of the ingredient or the supplement provides the secretary with the information that's the basis on which the manufacturer or distributor has concluded that a supplement containing the ingredient will reasonably be expected to be safe. That first highlighted "or" really matters. This is what the law says. Either the ingredient company or the supplement company has to provide this information. FDA's tendency in 2011 was to push the finished product company, that the burden would be there. That's, I believe, not logical. It's inefficient. We really want the burden to be at the ingredient side, and we want the notifications by ingredient companies to be broadly descriptive of the conditions of use for which they can substantiate safety, and that would greatly reduce the burden of these duplicative notifications. Next slide. And I'll show you here some of the differences between the 2011 draft and the current draft. So this starts with FDA asks if another manufacturer or distributor has already submitted a notification for a particular NDI, and I want to put that in my supplement. Do I also have to submit a notification? And FDA said yes. We commented that we thought that was true in some cases and inaccurate in others, that we thought that if the previous submitter is the manufacturer or distributor of the ingredient, then as long as they write the conditions of use clearly, that can apply to all of the companies, the finished product companies that put that ingredient in their supplement. The 2016 revised guide still said yes, but it clarified in that document that that was only if another dietary supplement manufacturer submitted a notification. And that might be rational. If a dietary supplement manufacturer submitted a notification and said, I'm selling this NDI in my finished product, that may not be sufficient for my separate finished product. But I think we did get a little where FDA clarified that it was the prior notification by a supplement company that would still require a second supplement company to submit a notification. Next slide. This is the same question, and to which we replied in 2011 that we thought that the most useful guidance that FDA could provide would be to suggest how those who wish to submit a pre-market notification for the ingredient would do so in a manner that would apply to a broad range of supplements containing the NDI. And I've got here an example. This one FDA acknowledged. They checked the right box. This company submitted a notification for their Fucodan extracted from Laminaria hyperborea, and they made it clear that it could be in either soft gel caps or tablets, that it could be in combination with other suitable approved food ingredients, not exactly the wording that either of the lawyers on the phone would recommend you use. But this was important, that the company said, we have established the condition of use as with other ingredients, as long as those other ingredients are ingredients that we're allowed to use, and then they put a condition of use against children and pregnant women. Next slide, please. And then again, now this is a different question. It's what if I submit an NDI notification for a supplement that I manufacture or distribute, and then decide to manufacture or distribute a different supplement that contains the same NDI. So I already did the work for my brand with my ingredient, and FDA stated both in 2011 and in the revised 2016 that it depends on these factors, which frankly are not unreasonable factors, that the intake level is the same, that your second product doesn't have twice as much of the NDI, that your new supplement doesn't combine the NDI with other ingredients that were not included in your original notification. Again, what we'll push for is use that very general language that says that with or without other lawful dietary ingredients. But if you were specific in your notification, you're kind of stuck with that. The target populations are the same, the other conditions of use are the same, And the one that I've bolded here at the bottom is that FDA, this is one of the conditions that FDA is saying, that they did not express safety or other regulatory concerns in response to your prior notification. They're essentially saying as long as you got the acknowledgement letter and not the letter of objections. Next slide shows that this language, next slide please, continues, or what we said in 2011 is that the draft guidance should remove any indication that FDA's evaluation of submitted NDIs will transform the legal requirement for marketing of dietary supplements that contain NDIs from the notification process described under the law to an FDA approval process. FDA knows this, all the attorneys there know that. This is a notification provision, not an approval provision. But FDA's retained that language. They're saying exactly the same thing now that they said 5 years ago. They're still saying that the conditions under which you could use your old notification with your new dietary supplement with the same ingredient would include that FDA did not object to that notification. We still think the agency is wrong. This is a point we're going to have to push back on again. Next slide, please. And so this is new language, though. This is in the new guidance. May I submit a single NDI notification that contains safety data for a range of conditions of use and covers multiple products? And the answer is yes. This is good. This is really what we've been promoting. Broadly described conditions of use for my NDI, so long as my safety conclusion is relevant to broad conditions of use with or without other ingredients at different product forms, tablets, capsules, liquids, powders. But what's interesting in here and what I bolded is that FDA is saying that this is only so with different formulations of pre-déchet ingredients in combination with the NDI. They're essentially saying, but not if you have even one more NDI in there. Again, I think that's wrong. The whole concept of approval of ingredients, this goes back to food ingredients also. If I combine two safe ingredients, I have a safe food, and that's generally the case. FDA did find a bizarre example of an exception to that, but we don't think guidance is supposed to be based on bizarre exceptions, but rather on the norm. And the norm is if I've got two safe ingredients, I should be able to combine those ingredients and have a safe food. But FDA repeats this, and I'll show it to you later. This also points out that if you are the supplement manufacturer or distributor and either you or the ingredient company have submitted an NDI notification that covers the conditions of use under which the NDI will be used in your product, you need not submit a new notification. That's important. That moves back from this suggestion that the burden is supposed to be on supplement companies. It's not. It's inefficient. The most efficient way to handle this is the work is done by the ingredient company with broadly described conditions of use. And then the agency also came up with this NDI master file. It's a good option as long as it's viewed as an option, as long as FDA doesn't think it's the only way to show that my different dietary supplement complies with the filing for that ingredient. It is a good option. Next slide, please. We proposed in 2011 comments that the identity information for the supplement could either be specific or general, either provided in a manner that specifically identifies each such ingredient when the NDI is used in a single supplement, or in general terms when the NDI will be used or may come to be used in more than one dietary supplement. And this, again, it's the identity information for the supplement. And FDA took this on in a series of questions where they were in the new guidance where they provide examples with an explanation to help distinguish situations in which separate notifications are required for a supplement containing the same NDI. Next slide will show you some of those examples. So here's a scenario in which, and I only pulled out the scenarios, there are 3 scenarios where FDA said, here's an example of that a new notification is not required for the finished product company. So the ingredients supplier submits a notification. The notification includes safety information for a supplement tablet containing that ingredient as the sole dietary ingredient with several non-dietary ingredients used as binders and fillers. My company now wants to use that same level of the same ingredient, but with a formulation with different non-dietary ingredients used as binders and fillers. And FDA said this manufacturer does not need to submit a separate NDI notification because the only difference is in the non-dietary ingredients. They do caution the second manufacturer should evaluate whether the change affects the safety of the finished product supplement and document the basis for its conclusion. But again, this goes in the right direction. If the ingredient company did a good job and I'm making a product that is compliant with the conditions of use described by the ingredient company, then I don't need a separate notification. Next slide, in scenario 3, provides a similar example. Ingredient supplement A submits a notification for its ingredient and includes safety information up to 500 milligrams. I've got it in my product at 250 milligrams. Now I want another product at 500 milligrams. Do I need a separate notification? FDA says no. Both of those products are within the conditions of use established by the ingredient company. And scenario 4 in the next slide is an example where the ingredient supplier submitted a notification that said that they might combine the NDI with several other named ingredients. I now want to make a product that is going to combine with some of those same ingredients, but not all. And FDA's conclusion in their analysis is I don't need to submit another notification because the ingredient supplier's notification covers all of the conditions of my use. Now again, what we've advocated for ever since we issued interim guidance almost 10 years ago, describe the other ingredients broadly. Unless there's a reason to think that your vitamin A is going to cause a safety concern with your NDI, there's no reason that you wouldn't say this notification is for this NDI under these conditions of use, which conditions include combining with other dietary ingredients as defined under the statute. Next slide, please. This is the one point in the, again, I'm repeating the same thing that we said in our 2011 comments, that we think the agency needs to clarify that the supplement can be broadly described. And in this list of scenarios, this one really stands out. FDA says a combination of 2 NDIs is itself an NDI. Again, I believe that we will push back on that in our subsequent comments. I believe that we're likely to say if you've got 2 safe ingredients and you combine them together, there's no reason to think that you've got an unsafe or even potentially unsafe foods, safe ingredients combined to make safe foods. Next slide, please. I'm going to move on now. That is about half of my presentation. I really think the biggest burden to industry is if this idea that every single finished product has to submit a separate notification, then we do have the billions of dollars of cost that you've heard some express as the outcome of this. But I think if we can control that well, push it back to the ingredient companies and the ingredients themselves, we don't need the hundreds or thousands of extra notifications. I'm going to move on. One of the other big deals that we raised in our comments that was important to our members is that the way that FDA issued the 2011 guidance, it would have put burdens on companies that only sell old ingredients. Just with this one question, what documentation would I need to show that my dietary ingredient was marketed prior to October 15th? And we said, you got to change that. What documentation would show? Because I don't need to show. The law does not say, step 1, prove your chamomile is old. It doesn't say that. The burden is on the Food and Drug Administration to show your ingredient is new. And so we pushed for FDA to just change this language modestly, and they changed it modestly. What documentation does FDA recommend to show that a dietary ingredient was marketed prior to the date? Now there's language below there that sounds an awful lot like should, but still I think this is some progress, and we'll continue to push for more progress in this area. Next slide. We proposed in our 2011 comments that FDA add point-blank state that there is no requirement in the law that manufacturers or distributors of ingredients or supplements have documentation to show that an ingredient is old, and then tell us how to do that if we wish to, and we ask that there be a new question, am I required to have documentation? And the answer to that is no. FDA didn't accept that challenge or request from us. Probably not a surprise. We'll probably ask for it again because we think it's clarifying. Next slide, please. And it really is clarifying, again, from if one of the goals, as FDA stated, of the guidance is to improve the rate of compliance with the NDI notification requirement, not to increase the quantity. They gave that up. Then if what we really want is just to improve the rate of compliance, then the agency's guidance should help us clearly understand where we do have a burden and where we do not have a burden. So again, we're almost certainly going to push back on that and maybe explain it a different way, make FDA see that there'd be a value in clarifying that the burden does not exist for me to prove my chamomile or my vitamin C is an old dietary ingredient. Next slide, please. We were also concerned about FDA's dismissal of the trade association's list of old dietary ingredients. They asked the question in the 2011 guidance, is there an authoritative list? They said no. They acknowledged that some of the trade associations, AHPA was one, CRN was one, NPA and NFA at that time was one. And they said none of those are authoritative, and they found problems with them. They found problems with it. There were some ingredients listed that clearly aren't dietary ingredients. They didn't report that the list that had these had them classified as drug ingredients, had them classified as excipient ingredients. They seem to want to emphasize some perceived error. And they also made a big deal out of that. One trade association even said they didn't independently verify it, so we're not going to accept the inclusion of these. There were actually two, both CRNs and AHPAs made that kind of disclaimer. So next slide, please. We said that FDA should take into account the processes whereby these lists and publications were compiled, as well as the spirit of their compilation, and that we noted in our comments or in our letter to FDA in 1996 that the list represents a compilation received from AHPA's members and non-members that specifically stated, we sent out a note, a call for herbs. We asked for companies to just give us the herbs that were marketed prior to the date. We clarified that this process was used all throughout our procedures in putting our list together, and that we strongly disagreed with the fact that trade associations told the truth about how their compiled and submitted lists were or were not reviewed constitutes evidence that they should therefore be dismissed out of hand. It just struck us as really just a complete rejection of our effort on a kind of a technical detail. Next slide. Well, here comes the new guidance, and FDA says the same thing. Not currently. And they go back into the same, we found some mistakes. You all disclaimed it, and so we don't accept these. So we didn't make any progress on this. Next slide. But FDA did say we're prepared to develop an authoritative list of pre-déchet ingredients based on independent verifiable data. But they'd have to get that information from us. Well, I'm going to have to stop here and tell just a short story of the one time that I went into the Food and Drug Administration's office with a document dated 1992. It was a catalog of herbs. I was there with 3 members of our Chinese Herbal Products Committee. They were having difficulty with FDA allowing some ingredients that we knew were old to come into the country. And so we went in to meet with them and to provide the evidence. So we gave them a copy of this 1992 list of herbs. By the way, it was one of the lists. It was a catalog from a company that when I was a manufacturer, was buying from. I knew that I was using those ingredients, that I was marketing those ingredients. And the FDA attorney in the room flipped through the catalog, noticed that the last page offered acupuncture needles for sale, said, oh, I see, this is a drug catalog. Because you're giving me a catalog that was also selling acupuncture needles, medical devices to acupuncturists, I know what these herbs were all being used as drugs, handed it back to me, do you have anything else? So complete dismissal of our very valuable and dated product because of a legal perception that they must have been drugs. It would take an awful lot for AHPA to cooperate in any process where we would supply information to the agency unless they're going to come forth with some more straightforward way of acknowledging. If you go look at the list of all of the things that they say document oldness, they're all documentation of finished products. And again, these are old dietary ingredients. The agency would need to acknowledge that records of ingredients being offered for sale constitutes evidence of ingredients being old dietary ingredients. It's also a little frustrating to us that they did not mention AHPA's Herbs of Commerce 1992 edition in the 2011 draft guidance, and now they finally got around to mentioning it. What they said is that's not good enough either, because we found a problem. You don't have the plant part or the extract type. Well, you know, you don't have to be very alert to know that the part of the chamomile that's used is the flower, and we didn't mean to say that chamomile root was an old ingredient, and I really think that it's just, again, dismissive and looking for some level of perfection so as to never actually develop a useful list. We sat in meetings with FDA over the last 5 years where every indication that we had is that that 1992 date on Herbs of Commerce constituted something, and so I think we were all surprised to see that now that they've mentioned it, they've dismissed it, and you'd better have some additional documentation. I want to remind you, you don't have to have documentation to sell an old ingredient. You just have an affirmative responsibility to act if you're selling a new ingredient. Next slide, please. A next issue that's really important and was in our comments, what manufacturing changes produce an NDI? And the FDA asked in 2011, should I submit a new notification if I change the manufacturing process for a new dietary ingredient that is the subject of a notification for that I've already submitted and received an acknowledgement? And FDA said at that time, yes, unless the manufacturing change does not change the chemical properties of the ingredient or the specifications needed to describe the ingredient. We said that shouldn't say yes, it should say it depends. It depends on exactly what manufacturing change occurs. And in the revised document, they did say that depends on the nature of the change to the manufacturing process. So we got a little closer. A couple more slides I'll let you in on that. I'm not particularly optimistic about this, but next slide, please. So a related question, if I change the manufacturing process for an ingredient that was marketed in the U.S. prior to the date and the changes alter the chemical composition or structure, does that make the ingredient an NDI? FDA said in 2011, yes, if the changes alter the chemical composition or structure. We said it should say it depends. And again, here's another place where FDA said the answer depends on the extent to which the manufacturing process change affects the resulting ingredient. Any changes in your manufacturing process that alter the identity will convert a previously marketed dietary ingredient into an NDI. We probably don't disagree with the words of that last sentence, but we are still going to have to struggle with and push back on exactly when the identity is altered and what manufacturing process does that. We spent a lot of time in our comments with expressing an opinion and a position that any traditional processing, pretty much processing that you could do in your kitchen, making a wine, ethanolic extracts, water extracts, basic food solvents, drying, any standard and traditional processing of an old ingredient should be seen as an old ingredient in and of itself. And FDA adopted none of those ideas. I think we had 3 or 4 pages. The word traditional is not in the revised guide. So I think that there's still a sense, both with me and others that I've talked to, but that FDA's idea of what constitutes a manufacturing change that produces an NDI, we need to push back on this some more. Next slide. I think I have one more point on this. Same question. if I change the manufacturing process, does that make it an NDI? And the answer depends on the extent of the change. Any changes in your manufacturing process that alter the identity will convert a previously marketed ingredient into an NDI. Manufacturing changes that alter the physicochemical structure or properties, or the purity and impurities or biological properties, result in an NDI. One of our members asked me, really? So if I manage to take my herbal extract and reduce the lead because I'm trying to come into compliance with Prop 65, I now have an NDI? That seems really not rational if the procedure that I'm using to reduce the lead is one that's really kind of simple and can be done without affecting the rest of the extract. So again, I think this is another area where we'll continue to question FDA on exactly what they're trying to accomplish. There's really not a value in trying to convert most dietary ingredients into NDIs. If we go back to the goals and what we're trying to accomplish here, I think that we want to move FDA in the other direction. Let's see if we can't focus on the few ingredients that are actually new, keep the burdens there, and move back on this idea that every time the wind blows from a different direction, it must be a new dietary ingredient. Next slide, please. There's also in the 2011 draft a very broad interpretation of the safety standard. I'm not going to read all of this, but you can see the extensive descriptions of the types of data that would help in assessing safety in a range of various described NDI scenarios, and here they all are. In the revised one, there's, and also the mention of the Red Book 2000 as a useful reference. In the revised draft guidance, the extensive descriptions are exactly the same, except instead of saying would help in assessing, they now say that FDA recommends to assess safety, and there's no mention of the Red Book. I think it's still viewed as a very, very, very high burden, but the next slide gives a tiny bit of relief perhaps in that, and this was true in the original draft and is now, are there scenarios in which additional safety data would not be needed if the proposed use of the NDI leads to intake levels that are the same or less than the levels consumed historically? Yes. If what you're selling is an ingredient that, say, is a South American herb that we just haven't used before, but we know that it's been broadly used in Brazil, and we want to bring that in as an NDI, or it's a simple extract of an herb that we have used before but not in an extract form. I think that this does say that when you've got something that's where the NDI is going to be used at intake levels that are the same or less than those for which there's already is a documented history of safe use, additional safety data are not needed. You don't have to go hire your own rats. You don't have to do multi-generation rodent survival studies. You're going to gain some relief from that great big list that whether or not the Red Book is listed is essentially a food additive approach. Next slide, please. Just a couple other details of interest I'm not going to get into, but I know they're often talked about. FDA has still taken the position that a synthetic copy of an herb or other botanical does not qualify as a dietary ingredient, so it's neither new nor old. It's simply not a dietary ingredient. Under subparagraph C, which is the herb or other botanical subparagraph, but it does qualify or may qualify under subparagraph E, which is the dietary substance for use by man to supplement the diet, if it's been lawfully marketed in the conventional food supply. And they gave here an example. I think this is unfortunate. I think it's a missed opportunity. I understand that essentially what FDA is doing is saying the word of means what it means, and as an example, synthetic caffeine is not a constituent of a botanical, so how could we allow it to be a dietary ingredient? But it is also funny to me that that same sharp attention to the meaning of the word of wasn't given to the meaning of the word or back when FDA wanted to talk about whether the ingredient company or the supplement company should submit a notification. And when I say it's a missed opportunity, again, if we could get focused on the things that really matter, it would probably be the better kind of guidance that we need to pull the industry forward and, frankly, to pull the agency forward in grappling with this tough provision. Also, a very high interest to me is that the 2016 draft guidance now mentions supercritical fluid extraction. That was not in the prior draft. And what they say point blank is that this extraction was not commonly used prior to 1994, and there's no evidence that extracts like they gave us an example, supercritical extract of lily of the valley, having been marketed as food prior to 94. I think that's really a heads up to all of the companies that sell supercritical extracts. You want to, it may be in your interest, even though I've said numerous times you don't have a documentation obligation, it still may be in your interest to go back into your older records and see what you can find, or think about filing NDI notifications and think about whether this would be that class where you don't have to go do extensive new scientific toxicology evaluations if it's essentially quite similar to the ethanolic extract that the supercritical extract replaced. Next slide, please. I just couldn't help myself. If Tony had had a chance to edit me, he would have made me throw this one away. But I just think, you know, that FDA is still harping about that because there's 55,600 supplements in the market, and they now estimate that 10% new every year. 5 years ago, they were estimating 1,000 new every year, and they want to contrast that to the number that were in the market in 94 and the very few numbers of NDI notifications. This doesn't make any sense unless you think that every new dietary supplement needs an NDI notification. We reject that idea. It's just, it really feels like piling on. It feels like FDA is looking for a reason to do all this work. And the next point is even more looking for a reason to do all this work. Whatever we're doing has nothing whatsoever with products marketed by criminals that contain undeclared active ingredients like sildenafil and sibutramine. Those are not dietary supplements. The Food and Drug Administration knows those are not dietary supplements. I have no idea why this sentence survives in this draft, and I just wouldn't give Tony a chance to take that little complaint away from me. I think that's it. Next slide, please. Yeah, thank you very much. I will now pass it on to Tony Young.
Thank you, Michael. I think Michael has given a very detailed analysis of how FDA responded to AHPA's very carefully drafted comments. Many hours went into that and into the meetings with FDA that followed. When the 2011 draft guidance came out, there were people in the industry running around saying the sky was falling. I want to guarantee you, in my view, the sky is blue, continues to be in the right place, and it's not falling. After looking at this revised draft guidance. Next slide. Let's look at the chronology here. The law was passed in 1994. There was an NDI regulation, a very simple regulation setting forth what's required in an NDI notification. It was published or made final in September of 1997, and it was non-controversial, plainly non-controversial. There was then a draft. There were public meetings. I believe there was at least one public meeting regarding NDI submissions. I believe I testified at that hearing, compared the NDI process at the time to the GRN notification process, recommended some improvements, namely feedback, namely the ability to withdraw a document before getting one of these nasty "we have objections" letters. And then we got a draft NDI guidance at the behest of industry and its congressional champions in July of 2011. and you would have thought that California was splitting off from the rest of the country through an earthquake. There was a lot of rancor, a lot of nastiness, both from the FDA, because at the time their spokesperson was not necessarily the most politic, and certainly from members of industry. And so it created a very, very bad atmosphere. We then had meetings with FDA, and now in August of this year we have this new guidance. Let's look at what FDA has been doing and how the process works now. As of today, there are 844 NDIs in the notifications in the regulations.gov database, but the most recently available response is dated October of 2014. So we're looking at a process that is dysfunctional even at FDA's level with 844 notices, in that it can't get those notices up into a public docket sooner than about 2 years after they've been made final by FDA. And of course that means that someone who's looking at that NDI notification and the response can't look at the NDI submission itself to, if you will, second guess FDA if they had some kind of objection. The other part of the NDI chronology is that there have been a number of warning letters, I think it's almost 50, regarding 16 different substances where FDA included in the warning a reference to no new dietary ingredient notification has been filed. Many of those are multiple letters. That's why I said there's 16 different substances. And for those who follow these notices, I'm sure you're aware of who they went to and what kinds of ingredients are being focused on by FDA in this context. Next slide. My primary takeaways are, it's a revised draft, and it means revised draft. Big draft. It's still a draft. The FDA's interpretation of the law in this draft guidance, as in the prior draft guidance, are intended to give FDA, its lawyers, its enforcement people, the greatest possible latitude in enforcement, and to create no fences or barriers to enforcement. And I've got a note to myself there, Herbs of Commerce 1. Herbs of Commerce 1, to those of us who work with AHPA, is pretty clearly evidence of marketing prior to 1994. It is also good evidence, noting that FDA has adopted it in the CFR with regard to nomenclature. And yet FDA takes the position that it's not good evidence because it doesn't list the part of the plant. Well, the part of the plant was not a required item of declaration for a botanical until Deshay passed in 1994. Certainly that doesn't disqualify this piece of prior information or any other piece of prior marketing information from use in demonstrating that something is an old dietary ingredient. And then finally, what all of FDA's guidance documents say, they do not establish legally enforceable responsibilities. And so the guidance document itself says that, and it gives FDA the opportunity to disclaim it as well. Next slide. There was one statement that I thought was, for the first time, kind of a signal of priorities vis-a-vis NDIs and whether to take action, and that is FDA's statement in the ODI context, old dietary ingredient context, whether FDA would investigate dietary ingredients not on an official list to determine whether an NDI notification should have been submitted would typically depend on factors relating to public health, such as potential for risk, extent of public exposure to the ingredient, and association with adverse events, which is what we believe to be the FDA standard for taking any kind of enforcement action. And so I think there's a signal here that certainly with regard to purported ODIs, and certainly with regard to ODIs that are on those industry lists, but probably a lot of other ingredients as well, that FDA is going to take a hard look before it tries to determine whether it's a new dietary ingredient requiring enforcement action. And their hard look is going to be public health, risk, public exposure, and association with adverse events. Next slide. My biggest concerns are with the investigators that are inspecting your facilities now at an increasing rate and at an increasing depth and an increasing amount of chattiness. I've heard recently that FDA inspectors are asking more and more information that's not required to be produced under the CGMP. They're asking for documents. They're interrogating companies about whatever they are interested in. And unfortunately, what they're interested in is likely things that they've read to be au courant, recent. And so this NDI draft guidance, revised draft guidance, could be one of those. Inspected companies are not limiting FDA inspectors to CGMP or other FDCA statutory documents required to be produced, and are answering most questions and emptying their damn files. Inspected companies do not understand, and this is a general rule. This is not. This is generally what we hear about as lawyers. Do not understand that FDA is not inspecting to help the company in its business. Next slide. FDA investigators do not understand, for example, that the food allergen labeling requirements that have been in place for 12 years, that there's even a question and answer on the FDA website that answers a lot of questions that they may have and not be sure about as an official source. I fear FDA investigators are going to begin interrogating and asking for documentation as a result of this 100-page revised draft guidance, because they'll read it and be intrigued with the enforcement possibilities that they can read about in there. So companies need to be aware of their rights during inspections, and they need to understand that they don't need to answer old dietary ingredient inspections or provide documentation to investigators just because they ask. Next slide. My other concerns about FDA is that new improved versions of old ingredients, well known to be safe, are brought to manufacturers every year. My new form of vitamin A, my new form of vitamin C, my new form of this, that, or the other. The revised draft guidance is going to stifle innovation on these kinds of ingredients and may serve to freeze formulations in place. It's going to be harder and harder to get new innovative forms of old ingredients into the manufacturing scene because of what this draft guidance says about them. If the industry were to follow the revised draft guidance and submit notifications at even 2 to 10 times the present pace, FDA is not staffed to handle the volume. They just don't have the staff to do it. And then if not staffed to handle the volume, FDA will ask for user fees. They ask for user fees now at almost any time they see a bottleneck in processing things that make industry go, that provide an engine of innovation or otherwise for industry. And Congress is more likely to legislate user fees than to change the law so that we could be facing user fees if there is substantial compliance with the level of detail and the level of requirement that FDA purports to impose in this revised draft guidance. Next slide. I have other concerns, state and private litigation. State authorities may utilize the revised draft guidance to enforce state laws regarding adulterated or misbranded products. We have the FDA affidavit that came to, I believe, the state of Oregon, possibly other states, with regard to Picamillin in October of 2015. Plaintiffs may do the same, at least with lawsuits. We don't believe, or at least I don't believe, that FDA would cooperate with plaintiffs' lawyers the way they cooperate with states' attorney generals, although sometimes you can't differentiate between the plaintiffs' lawyers and the attorneys general. Next slide, please. I think we missed one, Haley. FDA enforcement reality is that FDA, as Michael said, bears the burden of proving that an ingredient is an NDI for which no notification has been filed. I say again, FDA is going to evaluate any decision to proceed against a company based on actual or predicted risk, and most likely targets are easy for FDA, for dietary supplement formulators, and for retailers to figure out. You can look at FDA's past practices and get an idea of what the risk potential is with regard to ingredients that are brought to you for formulations. Next slide. The revised draft guidance to me is the best example of why this industry especially should evaluate under the adage, be careful what you wish for. In one of the first meetings we ever had with Elizabeth Yetley, who was then head of head of dietary supplements in CIFLAN, she cautioned the industry with that adage when someone in the room suggested that they might ask about some ingredients that had not been listed in an FDA notice. Her signal was, oh, well, we would give you the wrong decision on that. The lesson here is that in making excuses regarding NDI statutory compliance, the industry kept asking for guidance on how to comply. They got what they got, and that may not have been a wise course to use. We don't have enough guidance as an excuse for why there have been so few filings. Next slide. Thank you. Have a good one. Wes Segner will be following now. Wes?
Thank you, Tony. We've proceeded from Michael's, I'd say, semi-optimistic discussion to Tony's, although he had the blue sky in there. It got pretty dark at the end. And I have to say that AHPA has changed my slides, which were initially black with white letters, to something more peppy. But I'm the wind up here, and probably less optimistic about the future of where this guidance goes than Michael or Tony. But that's maybe why they invited me. I do want to put in a little plug for our blog, which is on the end of this first slide. If there are issues such as previous comments on guidance and who said what about various things, you can find pretty much everything there. Okay, next slide. And speaking of our blog, you can find our previous comments on the July 2011 draft in the first site there. And then we did a recent blog post on the revised guidance, and I think it's, you know, that goes through some of the things that Tony covered. I will spend a minute or two just talking about my perceptions of the 2016 draft, and then we'll get on to what are the options that industry might have here. Next slide. So, you know, Tony commented on this to some extent. The 2011 draft was not what I would call well received. Most of the comments were not just negative; they were very negative. There was significant pushback from Congress, and the end result, about a year out from the issuance of the 2011 draft, FDA agreed to redo the draft guidance, but they didn't agree to withdraw the draft. And we have seen, you know, some efforts to enforce some of the views expressed in the draft guidance, such as the no synthetic botanicals idea. Mainly those are being reflected in rejections of new dietary ingredient notifications rather than warning letters. But so the 2016 draft, kind of in our view, in terms of its major provisions, is not significantly different from the 2011 draft. Not taking anything away from AHPA or other trade associations, there was a very significant effort, as we know, to push back and try to get FDA to make changes. Some changes have been made, but these are some of my ongoing problems. This concept of grandfathering, you know, I should say, think of where we all be now if the trade associations hadn't gotten together within the last the couple of years after DSHEA and come up with a list, verified or not, of ingredients that they perceived as grandfathered. We're now, you know, 24 years out, and we're still struggling with this issue. It's going to be an ongoing problem, and as time goes on, it becomes perhaps more and more difficult to establish that something is grandfathered, and it is something that all companies should remember, that the burden is on FDA. You do not, I can pretty much guarantee that in future inspections you will get questions from inspectors asking to see your documentation of grandfathering. And as Tony, I think, was trying to point out, the appropriate answer is that's for FDA to disprove, not us to prove. And you might mention something about, you know, other companies marketing the same ingredient, which is usually the case with grandfathered ingredients. I also have not really seen much movement in this, in FDA's very narrow view of what constitutes a dietary ingredient. The two big issues that I see, one are this issue of synthetic botanicals. I mean, FDA, since the 70s, has said that it doesn't matter whether a vitamin is synthetic or natural in terms of source. It's still the same vitamin. If you have an ingredient that is an extract from a botanical and is a pure ingredient, there really shouldn't be any reason why you couldn't also manufacture that synthetically. The other big point of difference that we have with FDA is when it states as a criterion that you can have any dietary ingredient that is meant to augment intake. FDA views that as including only things that are already in the diet. You can't have new dietary ingredients, well, new in the sense that they aren't in the diet already, unlike on the food side, where you can introduce novel ingredients that are already in the diet through either GRAS affirmation or the food additive process, on the dietary ingredient side and supplements, you cannot truly have a new dietary ingredient because it already has to be in the diet to some extent. Then we have the narrow construction of the NDI exemption. The exemption states that a new dietary ingredient that is present in the food supply and is not chemically altered does not require a notification. Curiously, in that context, FDA is reading the word food to mean conventional food, not foods and including dietary supplements, which are also foods. And therefore, that's how they get to their notion that one manufacturer submitting an NDI notification does not make clear the way for other manufacturers or dietary ingredient providers to piggyback off that notification. Again, the irony here is that while DSHEA was supposed to be kind of an answer to FDA's misuse of the food additive provisions to keep dietary supplements off the market and to provide more flexibility, we now have a system that is less flexible, if you accept FDA's guidance, than the situation with food additives and GRAS food ingredients. So what this is, I mean, again, if you accept this, and some companies are because they are conservative and want to market products that will be accepted by conservative food companies. Again, ironically, the better way to market in some cases is to take a new ingredient, get it self-affirmed as GRAS, and then introduce it into food. And if you do that, you should do it in an amount comparable to the amount you would have in the dietary supplement, and that would, theoretically at least, FDA may come up with some reasons not to like this, but it appears from their new draft guidance that they accept this route. That would theoretically exempt you from notification. Then finally, Michael and Tony covered the manufacturing issues. There's some things in that within that context, such as FDA's statement that as long as you don't change or alter the identity of the ingredient, then you should not need a new NDI notification. I'm not sure what they mean by that. If it's impurities and such, or is it just the chemical composition of the specific ingredient? Anyway, that's something that I never anticipated in reading DSHEA, and I think is true of others also. Finally, I think we need to consider this guidance in the bigger picture, although in my view it's very similar to the guidance back in 2011. The regulatory situation is different, and I feel that FDA may be thinking that at this point in time it's safe to reissue a very similar guidance, in that the industry is under additional pressure from state AGs, talking here about the New York AG effort to pull in the retailers on ingredient issues, also the lawsuit against GNC in Oregon over ingredients, picomelon and BMPEA, even though in both cases GNC had pulled products from the market before FDA issued warning letters. But the reality of the picture is that industry is under pressure, and I also want to mention on the DOJ side, of course, the USP Labs indictment. Next slide. Now, so let's move on and talk about options. At this stage, there really isn't a litigation option. Tony mentioned that guidance is non-binding, although in some cases, FDA has been successfully sued for saying that the guidance is non-binding when in fact they are instituting regulatory-like rules within the guidance. But we haven't even gotten to a final guidance yet, so clearly litigation over the guidance at this point is not an option. There is a comment period, and NPA has already asked for a 30-day extension, which I think should be longer, but that's one request that's already gone in. My notion, my feeling about comments is that we didn't make a lot of progress last time, and filing critical comments again this time is likely to have much the same effect. Now, I do think that some progress can be made, and I'm not saying that that the trade associations should not continue efforts to push back. That clearly needs to be done. But I don't expect that the final guidance, if it is ever issued, will be all that much different. Next slide. So, if we accept that FDA's draft guidance and the final guidance are likely to be much less flexibility than we would expect under DSHEA, what can industry do beyond simply objecting again to the draft guidance? Well, I think there is kind of a shift of focus that's been occurring over the last year or so, in part as a result of the NYAG investigation. And that shift this is something that's the trade associations have always been encouraging and have been developing to some extent, but I think it's a growing trend in the industry toward more self-regulation, more vetting of vendor and ingredient quality issues, funding of NAD reviews on advertising claims. Industry is working toward developing a product registry, which I think will eliminate a lot of the constant criticism that FDA has nowhere to go to look to find out what ingredients are on the market. GMT certifications, of course. The same kind of thing, and I'm going to purposely not be very specific here, could be done on the NDI side, both with respect to adopting accepted standards for what is and what is not an NDI, and what is not a dietary ingredient to begin with. And obviously, I think there are ways to prepare notifications that could make it very difficult for FDA to object, and if FDA did object, it would make it easier for industry for the company following the notification to simply say, well, look, we and our experts disagree, and we have complied with the law. We have notified you 75 days before marketing, and that's all that's required. Obviously, if you're going to take a stand like that, you need to be very certain of the safety of your ingredient. But the object here is that more emphasis on self-regulation provides industry with opposition an opportunity to disagree with FDA in a more constructive way than just saying no. You need to have a basis for saying no and why we're right, and that has to be a solid basis. Next slide. So, I think through the self-regulation idea, we can get to a process for NDIs that is more consistent with DSHEA. This next point may be a little optimistic. I've worked with this industry for 30 years. Occasionally, I would say more than occasionally, it tends to be a bit disorganized. There are a lot of different perspectives, given the wide range of products, and that's to some extent to be expected. But what FDA's, we should not let FDA divide this industry. This NDI issue should be a uniting point. We should be able to agree that FDA intended flexibility and try to assure that. Self-regulation in other industries to a larger or smaller degree has helped avoid the need for agency enforcement and less enforcement because of fewer problems would be a good thing. I don't, again, I can't predict when there'll be a final guidance, but to the extent there is one, if we have self-regulatory process in place, that will help push back as well as with warning letters for companies that might receive them. Finally, it helps with messaging on the Hill. Next. So rather than, you can read the conclusions here, which are just a reiteration of what I've just said. I did want to touch base quickly on a few things that Tony and Michael said. I agree that this offer to help develop a grandfathering list, as Michael pointed out, is, well, it's maybe not worthless, but I don't really believe that FDA is sincere in that. I do think that industry, to the extent the trade associations have developed a list and have tried to refine it, I think we could refine it further, but industry and trade associations is really the place to look for any kind of list down the future. I want to again say that Tony's advice on inspections was excellent. Every company should have a memo distributed to anyone who's dealing with inspections, advising employees how to behave in inspections and what FDA is entitled to and what they are not entitled to. FDA inspectors are trained to ask for things that they don't have authority to look at. And they are also trained to ask for interviews. FDA has no authority to interview anyone during an inspection. Obviously, it's difficult to have an inspection if you don't have someone talking to the inspector, but they are not permitted to ask questions of random employees. You can allow them to do so, but you should be very careful in that. The last thing I would mention here is the issue of imports. A lot of these ingredients that we're talking about in terms of NDIs are imported, and FDA is seriously ramping up its process for detaining any ingredient or product that it does not approve of. And that is, I would predict, the most, the easiest enforcement tool that FDA can use to try to enforce whatever the NDI guidance is in the end. Because in the import situation, the burden is not on FDA, it's on the importer. So all of this in terms of proof of grandfathering and proof of presence in the food supply or whether it is or is not requiring a notification, that shifts all the burden to the importer. And if you can't get the ingredient in the market into the U.S., you can't sell it. Thank you, and we look forward to answering questions.
Okay, I'd like to thank you, all of our presenters, and I think it's best if we go straight into the questions that have been submitted so far. I will direct these questions to whomever is the presenter, and then leave it open to the other presenters to just chime right in. The first question, on page 26, when discussing chemical alteration, it mentions, quote, changing agricultural conditions to alter the structure of the ingredient. What agricultural changes would require? For example, would an ingredient that has historically been wild collected that is brought into cultivation require an NDI, or an ingredient that is bred through traditional breeding techniques to have a consistent level of constituents?
This is on page 26 of the guidance. I assume changing agricultural conditions to alter the chemical and molecular composition. Now, I don't think it means growing it on a hillside instead of in the woods. I think that other part, to alter the chemical or molecular composition, and it gives as example sprouting garlic or fermenting yeast using a medium containing large amounts of sodium selenite to create large amounts of organic selenium compounds. I would probably say sprouting garlic. We're going to go back to, that's a traditional food process that we've been doing that for several thousand years now. But I don't see that this says moving from wild harvest to cultivation, because that is not to, quote, alter the chemical or molecular composition. If I misunderstood the question, please ask again.
Did anyone else want to chime in on that question?
I think Michael's the best. This is Wes. But this, I think this question illustrates the concern that we have about herbal products and extracts in particular, in that if we start really looking at the changes that can occur as a result of harvest time or different areas of growth, my understanding is there's a fairly wide variety of changes that might occur within the plant and possibly the extract. And if FDA is really going to focus on that, they might be, they may be calling a lot of those things new dietary ingredients that require notification.
Okay. Then I'll move on to the next question, and I believe, Michael, you would like to address this. And that question is, how do you know what has been submitted to FDA as NDI from other drug ingredients or dietary supplement companies, and where are these located?
Tony mentioned that you can get them at regulations.gov. They're not very well organized. The only place that I know that they're well organized is the AHPA NDI database, which is ndi.ahpa.org. We've been keeping these in order for 8 or 10 years already. It's a subscription database that's very affordable, both for members and non-members. But, the same frustration that Tony expressed, we've experienced here. We don't have any documents for the last, we have maybe a handful of documents that are newer than 2 years old, because the FOIA system's not working well, and we're not getting these documents timely. But that, as far as I know, that's the best place to obtain all of these. I do want to mention one thing, and we also have submitted a request for extension of time. Both AHPA and CRN that I'm aware of submitted requests, and NPA, as Wes mentioned. We asked for 90 days, hoping to get 30 to 60. Because we really don't think that we can submit comments 2 days after Supply Side West closes. It's just not enough time also.
Okay. Moving on to the next question. Is there a grandfather status for products that have self-affirmed GRAS as of today and no NDI submitted as of today? And will an NDI be required in the future?
This is Tony.
Okay, go ahead.
I'll talk and then Wes can. Self-affirmed GRAS doesn't make a dietary ingredient. If an ingredient is self-affirmed as GRAS for use in food and then used in food, it can be used as a dietary supplement ingredient. It is a new dietary ingredient because it's never been used in a dietary supplement before, but it's one for which no notification is required under the statute.
Yeah, I agree. There's the question. It's not a grandfather status question. Assuming these are ingredients that are self-affirmed after 94, then they're all NDIs. They just don't require notification. And as I mentioned, that's become a fairly common way to get ingredients into dietary ingredients without having to submit a notification. If you look back to pre-94, the FDA process first, well, there was this, industry was able to, and has always been able to, self-affirm as GRAS. But in the past, before 1994, and actually up until 1997 or 9, if you wanted to notify FDA, you had to go through an affirmation process with FDA, and FDA simply was not reviewing those filings to any significant degree. So FDA has developed a notification process for GRAS self-affirmations, and it's a very efficient process compared to the NDIN process. So a lot of companies are seeing that as a better route to market for dietary ingredients. You self-affirm as GRAS, and you may or may not notify FDA, but you can notify them and get a no object letter, and then market as a conventional food, which then exempts you from notification for the NDI and the dietary supplement.
Did Natasha fall off?
I'm not sure what happened with Natasha here. We can just continue down. We had a quick question about NAD review and what that means.
Okay, well that was my failing, but NAD is the National Advertising Division of the Better Business Bureau, and they have a self-regulatory process for reviewing advertising claims, not just for dietary supplements, but other products. And several years ago, industry through CRN decided to provide funding for NAD reviews. Typically, in the past, they had been funded through competitive challenges. If you're a competitor and you wanted to challenge another competitor's advertising, you would pay a certain amount of money to NAD, and they would go through this advertising review process with your competitor. Now, because there's additional funding through this self-regulatory initiative, NAD launches its own challenges to advertising that it views as somewhat out of line or questionable.
All right, thank you.
Okay.
Natasha's back. Go ahead.
Yes. So there are many ways to dry food and herbs. If a new dryer is installed, no solvents are used, is this considered a MC, and does it require submission for NDI? Or are dryers considered to be a desiccator as used in drying food?
Michael?
Why don't we hold that for Michael and move on?
Okay, move on to the next question.
I was on mute, sorry. I certainly don't see, and I'd love to hear the lawyers opine otherwise, dehydrating a plant, I don't believe, creates a new dietary ingredient.
I would agree. I guess, if I'm putting on my FDA hat, and if it was a high temperature drying process that somehow changed the product, such as proteins or otherwise, they might take a different view. But it would seem to be pretty clear that the answer would be no. It would not be considered a manufacturing change to me.
And also, isn't that one of the, even if we say maybe it is a new dietary ingredient, but isn't it, it's one of the exceptions to chemical alteration. So even if it's an NDI, it would be an NDI for which no notification is required. I'm opening that up right now. Dehydration, milling, those are excluded from the definition of chemically altered. So even if somebody wants to say that dehydrated tomatoes are a new dietary ingredient, so then it would be an NDI with no notification required.
And Michael, is that the same for foods that are dried, milled, and tableted? Because that's also another question that just came in.
Dehydration and milling are both, as is freeze drying, those are all exempt from the definition of chemically altered. And tableting, that's not a, I mean, I guess you could make a tablet out of an ingredient, but you know, it's an ingredient until you make a finished product out of it. I would not consider tableting as an ingredient process. It's a finished product process. Tony, Wes?
No, I think you're correct.
I'd agree. Yeah.
Okay.
Yeah.
So I'm going to move on to the next question, and I believe, Michael, you indicated earlier that you'd like to address this question. For one of our raw material components, we have a statement from the manufacturer that states, quote, the NDI notification of X has been acknowledged by FDA. Part A, if we are selling this product as a standalone, do we need to also submit an NDI notification? And Part B of the question, if this ingredient is used in a formula with other ingredients, do we need to submit an NDI notification?
Yeah, let me try to answer it in three parts. One is if your ingredient supplier says this NDI notification, or the NDI notification for this ingredient has been acknowledged by FDA, ask them for a copy. They're publicly available documents. They shouldn't be unwilling to give you that, because you want to see those words where, I mean, you want the two-letter response. Might as well put that in your files. And then part of what you want to see is what are the conditions of use described in the notification. And if I take the perspective of FDA's draft guidance, it seems that if you're selling the NDI as a standalone, do you also need to submit a NDI notification? FDA has said no, as long as the amount in your product doesn't exceed the amount in their described conditions of use. And if it's with another ingredient, FDA has said yes if those other ingredients were not described in the conditions of use of the original notification. Now that's just applying the draft NDI guidance. I think at this point I'd love to have Wes and or Tony talk about what happens if you apply the law. What does the law say about this?
The law says that a dietary supplement would need to be notified.
Doesn't the law say a dietary supplement or dietary ingredient?
Yes, but I thought
or marketer.
Yeah, are you saying if the dietary ingredient notification includes your formulation?
I mean, the question wasn't clear on that, but I guess we could suppose certainly if the NDI notification for the ingredient said combined with exactly the ingredients in your product, then we're done. What if the NDI notification for the ingredient did not say also with vitamin C, also with chamomile? There's a new NDI required as you understand the law.
Well, as I understand the law, there is a provision for notification regarding the dietary supplement. And the dietary supplement is the one with the 5 ingredients, not the one that is simply the single ingredient.
And Wes, you agree with that?
Well, I think you could read, my read of the notification requirement is that you have to have a new ingredient, and the focus is really on the ingredient, even in, as it's presented in a product setting. But as with food additives and GRAS substances, if you have already done the review and it's been notified and you're simply adding it to another formulation, where there are no other new dietary ingredients, then you don't need to notify. There is this question that FDA raises, which is also true in the conventional food context, that there are potentials for adding different ingredients and creating questions about safety. Those are questions that the company needs to assess and evaluate, but they're not ones that require notification in my view. The company, again, DSHEA, as with on the conventional food side, the GRAS and food additive law, regardless of what is reviewed and isn't by FDA, the onus for safety is on the manufacturer. So, there should be evaluation of changes in manufacturing and different formulations for ingredients, regardless of whether there's a notification required. But it's a separate legal analysis, and the other one's a safety analysis.
Okay, so we're going to move on to the next question, and that's if a NDI is used at the same level but with other ODIs, NDI application, does a new NDI need to be filed?
FDA would say yes, and then I think I just heard Tony Young and Wes Signer disagree on that as far as the reading of the law.
No, Michael, the word dietary supplement appears at the end of that sentence. The ingredient manufacturer or the dietary supplement manufacturer can make the submission regarding the ingredient when used in a dietary supplement, and the dietary supplement has to be described in the NDI notification for the ingredient, or in the or by the dietary supplement manufacturer. I mean, that's what the law says, and FDA hasn't backed away from that provision at all. And that's what they say in the guidance, in the revised draft guidance.
Okay, so here's my read of this: is if it's an ODI, then it's exempt from notification in and of itself, and because under it's present in the food supply. Now FDA disagrees with that because they're saying it has to be conventional food. It doesn't apply to anything but conventional foods. And if you have an NDI that's already been notified and you're adding ODIs, then in my view, everything in that product is subject to the exemption. So I'm not sure whether I'm agreeing or disagreeing with Tony, but so anyway, we may have three different answers to this question, but
and I think part of that is because this isn't black and white. The Congress did not take the time to describe every scenario, so there is some openness to interpretation. I think it's difficult to, and this is just another opinion here, it's difficult to read it a different way than Tony's presenting it with regard to where the term dietary supplement is placed in the provision. But I think it's also difficult to disagree with Wes's view that if all you have is safe ingredients, I mean, now I'm paraphrasing my own comment earlier, if all you have is safe ingredients, you have a safe supplement.
Yeah, and I would also
we need to go back to to FDA's to two principles here. One is FDA gave this draft guidance the broadest reach possible, and so that they would never be fenced in. And second of all, they said at the same time that risk, exposure, adverse events and you know, kind of common sense science about, I believe, what the final formulation is, because that's what they're talking about, dietary supplements, is what they're going to be looking at.
Right. No, I agree. And there's no surprise that FDA has interpreted the law to, as Tony says, provide as much flexibility and enforcement as possible and avoid being fenced in. But you know, my concern, I think all of our concern in that respect, is they've interpreted it with such broad expanse that in order to actually try to comply with the guidance, we will have an onslaught of you know, and if people did try to comply, there would be you know, a 10-fold or 100-fold increase in notifications, and then we may be looking at user fees. On the other hand, I also agree with Tony's perception. I mean, basically, we're talking about regulatory risk here to some degree, and if all you're talking about is ingredients that have already been reviewed and are considered safe, your regulatory risk should be very low.
And I think, you know, Wes mentioned self-regulatory efforts, and related to that are industry guidance efforts. And hearkening back to something that I said a number of times, what we really need is to get good training on submitting notifications where the conditions of use are broadly stated. And if that's the case, then the question that we're now struggling with here, if you're putting a new dietary ingredient in a product with some old dietary ingredients, and the notification for that NDI said in use up to, you know, 500 milligrams, and you're staying within that, with or without other dietary ingredients in a tablet, capsule, liquid, or powder form, and that's the notification that was submitted, then the answer would be, you're fine, no notification is required. And I think that is, you know, it behooves us to really push kind of a training for industry, especially the ingredient companies, to encourage broad descriptions of the conditions of use, so long as the evidence that's the basis for your conclusion of safety can be accurately applied under those broad conditions of use. And again, most safe ingredients are fine with all other ingredients.
And Michael, do you expect political pressure from Congress with regards to FDA on their guidance like that was experienced in 2011?
It's hard to predict now. I think it will depend on whether industry, when we get more into the details, if we're very troubled by this, then we would probably go to the Congress and try to increase their interest on this. I think it's not as likely, though, both because of the change in makeup of the Congress and also because there does seem to be just the energetics. You know, last time when this thing was released, there was an outpouring of fury and opposition, and this time there seems to be more of a scrutiny and a looking at progress made and progress still needed. Maybe it's just a difference in the relationship with the new Office of Dietary Supplement Programs compared to where we were 5 years ago. I think that resource is available if we need it. I don't think we've decided we need it.
Okay. Without real definition of nanotechnology, do nanoscale ingredients that are currently marketed and have been for a decade have an NDI submitted in response to the new draft guidance?
FDA has been nervous about nano ingredients, not just in our class. I haven't followed it too closely, but I think that the agency does think that you have to look at a nanoparticle as You know, again, what they say in the draft is application of nanotechnology that results in new or altered chemical properties of the ingredient. So
Yeah,
does that mean
I have to go back
itself?
and look. Yeah, Michael, I have to go back and look, but I seem to recall that somewhere they make the point that if you have an old ingredient and you nanoscale it, that's an NDI, you know, per se. And I'm not sure about that, but I agree. I would be actually, and even if it doesn't, I would be surprised, you know, and given FDA's concerns about nanoscaling, that wouldn't be the case.
In your opinion, is there any way FDA could, under any circumstances, characterize well-known historically used herbs like saw palmetto or milk thistle as products requiring NDIs?
Nope. One man's view. Tony, Wes?
Of course, there's a way FDA could do anything they want to do. I can't. They can't limit it, and I would assume that there's a way to process saw palmetto or a way to process, what was the other ingredient?
Milk thistle.
Milk thistle. Yeah, I would assume you could process those in such a way to give them new properties or enhanced properties in such a way that FDA, under this guidance, could find more than one sentence that would apply and cause it to be an NDI.
Maybe I misunderstood the question. I thought the question was for unprocessed saw palmetto, not for newly processed saw palmetto. Saw palmetto berries. Can they make apples a new dietary ingredient?
Yeah, well, and even there, I guess you could, if you take, for example, there was a situation a few years back with red yeast rice where some Canadian company was, you know, growing it to augment methacholine content and advertising it on the website. And we had a client get in trouble on an import, actually had an import refused as a result of the website in China trumpeting the you know, the altered content. So if there was some way that they were growing things to make, you know, to augment the constituents of the herbs, that could create problems.
Agreed. But again, I read this as ground up milk thistle seeds.
Oh, that's not what it says. It says historically used herbs like saw palmetto or milk thistle.
Right, and this historically used milk thistle is ground up seeds.
Okay, that's fine. And if that, yeah.
Right, they're not going to be coming after chamomile flowers. And I mean, and the basis for my simple one-syllable response is, and we had this discussion with FDA at their office, they understand they have an evidentiary burden. They can't make it up. They can't say, we decided we don't like the shape of milk thistle seeds anymore. They actually have to have some reason to believe, some evidence that milk thistle is new. And we don't think they can find that kind of evidence. You know, where they have taken the position, Tony mentioned that, 12 or 14, 16 cases where they said, you know, we believe we have an evidentiary basis for taking the position that kratom is a new dietary ingredient, and we are therefore going to act. And at that point, they shifted the burden. But yeah, absolutely. I mean, I'll also agree with Tony. You go make brand new super duper extract never been heard of before of milk thistle, that's a new dietary ingredient in FDA's view. Just because the source ingredient is old does not mean every extraction or finished product therefrom is also old.
This is a question specifically for Wes. Were you obliquely suggesting an ingredient review process like that used by the cosmetic industry?
Well, obliquely, As you know, the cosmetic industry has long succeeded in avoiding a lot of the issues that supplements have had, but that they're not immune to that type of questioning either. Obviously, there's and the scrutiny's been ramping up. But I do think that I mean, the notification process is just that. It's a notification process. And that opens the door to supplying FDA with notifications that the company is willing to stand behind, regardless of what FDA's view is of the notification. A filing by FDA does not really have a legal impact. It may have an impact on the willingness of, if you're an ingredient supplier, of your customers to accept it. But if you're a manufacturer, and again, willing to stand behind the notification because it's been backed up by experts, then you could have a process to, such as a certification process, maybe to get that done. And so to that extent, it would be self-regulatory and outside the government, and therefore somewhat like the cosmetic review.
Okay. Does the pre-1994 supercritical exclusion still apply if a supercritical CO2 extract has a similar composition and identity to a traditional ethanol extract?
I don't think there's a certain answer. That's not a black-white question. I think, is there an argument that you can make? Yes, there's an argument that you can make, and you should. And you should document it and put it in your files if you decide that all your supercritical extraction did is produce the same ingredient more efficiently. You would want to document that. Whether that's going to make it so that FDA never disagrees.
Yeah, I agree. That, again, the stress here should be on safety, which is really, in my view, mainly the manufacturer's responsibility for these kinds of issues. And if you have it documented as Michael suggested, which would be also include a scientific assessment of the lack of, change in the ingredient or combination of ingredients, then I think the FDA may not in the end agree, but your regulatory risk is very low on that.
Doesn't the guidance say that to use a NDI filed by a different company or supplier, you need a written letter from that company or supplier to use the NDI notification as your own?
What I read is, if you choose what I called the option of using the master file, yes. But not every ingredient company is going to choose to use the master file. They might just get their notification done, and as we saw in another earlier question, let all of their potential customers know that they have this NDI notification submitted to FDA and receipt of a letter of acknowledgement where the conditions of use are broadly described, and you can go forth and prosper in selling our ingredient and your finished product that complies with our notification and the conditions of use stated. There should be no need for a notification in that situation. If you also want to notify through the use of the master file, I believe I agree with that. I will admit I have not studied the master in great detail, but I do recall seeing something about that you'd get permission of the ingredient company to use the file.
Okay, the next question, has the relevant government legal department reviewed the guidance yet? Will they? And would it be helpful to know their take on the legality of some of the provisions that we believe are not legal under DSHEA?
Well, FDA's lawyers looked at this, you can be sure.
Oh yeah, their fingerprints are all over it.
And that's the relevant legal department here.
And the second part of that is, Do we know would it be helpful to know their take on the legality of some of the provisions that we don't believe are legal under DSHEA?
I think the easy answer is that they would view them as all legal under DSHEA, otherwise they wouldn't have permitted it to come out the way it did. As Michael noted, a lot of these things are subject to interpretation, and so there's going to be differences in interpretation.
Yeah.
Okay. The next question, will CEF-affirmed grass still be acceptable from dietary ingredient suppliers, or should they be getting the FDA-approved grass RINDI?
This doesn't affect self-affirmed grass ingredients. As Wes indicated earlier, pre-DSHEA, they would be food ingredients, and they would have been used in food pre-DSHEA. Post-DSHEA, the ingredients need to be self-affirmed grass and have been used in food. I do believe there may be some misunderstanding among ingredient suppliers as to the second component, that it has to have been used in food before an NDI notification is not required. So that a lot of ingredient suppliers may tell you they have self-affirmed grass, and they may either show you a black box and tell you there's a self-affirmed grass in it, or they might even show you the self-affirmed grass under a confidentiality agreement, which is normal business practice, by the way. But they have to give you one other thing, and that is to show you that it's been used in food. It would be a new dietary ingredient, but notification is not required.
Right, and there's a third possibility, which is if you're the company thinking of purchasing this ingredient, you may choose as a business policy that you're only going to accept ingredients that have also been self-affirmed and notified, as well as used in food, so that you have FDA's no object letter. Now, whether you do that or not is, as I said, a business judgment. If you're General Mills, you're not going to, you're going to want to have that FDA notification. If you're selling to a different market, you may choose to say, well, self-affirmed by this expert panel with evidence of use in food is sufficient for me.
And Wes, by that you meant a grass notification to FDA, not an NDI.
Correct.
Correct. Grass notification.
Right. Grass notification. Right.
Wes, this question is specifically for you. You mentioned division in the industry. Did the FDA already succeed in doing this since CRN embraced the draft guidance?
Well, I don't think the FDA causes division in the industry. That would be maybe they're out there. Michael might know more than I do, but the division naturally exists, and it's understandable in that there's different, a lot of different types of companies within the industry. I think to some extent, and again, I'm sitting on the outside of the trade associations, and so therefore don't have to worry about trying to make everybody happy. But the trade association is going to pay attention to their members, and more or less, sometimes they direct, the members. But I really am not privy to why CRN embraced the guidance, and I'm not absolutely certain, what they've said to this point. Michael's probably much more up on that. But it wouldn't surprise me that some trade associations would say we think it's fine, and others would say we don't like it at all. And yes, I suspect that will happen.
Yeah. I mean, I've seen comments by most of the trade associations. I think to characterize what CRN has said is to embrace it only got kind of the headline. I did hear other comments from CRN, from Steve Mister, that they too will push back on some of the details. I had a meeting with several other trade associations this morning, and what we all agreed to do this morning is to share drafts to make sure that we're looking for opportunities for cooperation and minimizing opportunities for disagreement. Again, I saw the headline on that article, but I don't think it tells the whole story.
I think in this, again, this is Wes. As a trade association, there is a tendency to be more politic, which is not something that I really need to worry about, given that I'm representing individual clients and I'm representing their interests. You know, and that's a much smaller group and a more defined group than Michael or other trade associations heads have to worry about. So it's a different dynamic, and I can see, you know, saying, well, you know, that we embrace it in that there's some progress here and it's just a draft, so we're going to work with the agency to make it even better. Yeah, that's not necessarily accepting it as a whole, but again, saying words that are intended to promote further discourse.
Okay, well, I would like to thank everyone for your time and your energy and effort. And on behalf of AHPA's Education Committee, I do thank you once again for your participation today. You can check our website, which is www.ahpa.org, for upcoming events. We do have our 5th annual AHPA Botanical Congress that's scheduled for October 8th, immediately following Supply Side West, and you can register on our website. Again, I'd like to thank our presenters. This does conclude our webinar, and I believe Haley, before you sign off, has some housekeeping reminders. Haley?
Thank you very much. Thanks again, everyone. If you have any issues, questions, feel free to email us at ahpa@ahpa.org, or you can give me a call, 301-588-1171, extension 104. There's a brief survey after you exit the webinar. We encourage you to fill that out so we can continue to improve these events. And you're going to get an email here in the next 24 hours with a link to download all the materials and the recording that you can view on demand. So thanks again, and have a great day.